the Supreme Court would be open in how it dispenses justice. So it's extremely befitting that 12 years down the road, we sit here to ask ourselves, to what extent has the Supreme Court lived true to the constitutional dictates in Article 163 of the Constitution? To what extent has the Supreme Court adhered to that guidance from its first president of neither wavering nor favoring and of being open in the dispensation of justice? Together with me are four distinguished gentlemen. At the absolute right is Fred Ojiambo. Next to Fred is Attorney General Emeritus Professor Githu Muigai. When Professor Githu Muigai taught me in law school, Professor Githu Muigai used to tell me that if the law is on your side, please hammer the law. If facts are on your side, please hammer facts. If neither are on your side, please hammer the table. Professor Muigai, please don't hammer the table today. Next to Professor Muigai is Protas Gadege, the chair of the International Commission of Jurists Kenya section. And next to me is the bandit from some place next to northern Kenya called Kaulo.
Because they felt that you just need a little more, a court which was not hampered by too many technical impediments and would look at the law in its broader sense, see how the law applies to the community and to the society, and to be able to be more concerned about human rights, concerned about the expansion of a civil space. And there are many people who then contributed to a debate in that regard. And I think some of you will recall, maybe I shouldn't talk like that because I don't know when some of you were born, but some of you will recall the discussion that went on towards the change of the Constitution discussion, and some of the views that were expressed very strongly during the actual conference at Bomas. And you will see that there are various reasons why that might be done. But anyway, to cut the long story short, in the Constitution 2010, the transformative from the very start is that the jurisdiction of the Supreme Court was a lot more limited than some people had hoped and had wanted, because it was limited to deal with issues, first of all, to deal with the presidential elections, then to deal with issues that related to the Constitution, either the interpretation or the application of the Constitution, and any other issue had to be certified to be one that raised. But then, when we look at it a little more carefully, we realize that it is, in fact, in many ways, a transformative document.
Since that constitution was promulgated, came it, and these are especially individuals who are involved in agitating for civil and political rights. We have had instances where there have been abductions that at a very high rate. Recall during initially, the right to assemble was respected, but only for a short while. Thereafter, with that continued push, there were quite a number of disappearances. There were some abductions. Some, I think, a couple have never been found to date. There are those who were found dead. There are a few who resurfaced, and the stories they gave were not in any way very exciting stories. So those are threats that we are seeing currently. There is a restriction to the freedom of assembly and expression that has come in. Say that we would ask for the Supreme Court to continue highlighting these issues that
in a very clear context, which is what? The sovereignty of the people is donated to organs of government. That is what it says. Although we never read the whole article. The sovereignty of Kenya is with the people, which they may donate. Where to find them if we had a comment about it. And what the new constitution was
34A. But lesson number one, like all High Court judges, like all Court of Appeal judges at the time, and a lot of the advocates seated here and elsewhere, we all thought the Supreme Court was completely lost saying about the American Supreme Court, we're infallible not because we are. Njerithuku, we're infallible because, or we are not infallible because Supreme Court judges have the most difficult task of never trying even to think of being wrong. Because of the finality of decisions of the Supreme Court, you must get it typically to the best of your...
I think is one of the things that has assured our democracy. We probably haven't got to it yet, but we're certainly going in that direction. And this case really set it out, in my view, very well. Also suggesting, of course, that the public participation shouldn't just be illusory. It should be plain, it should be clear. It should be something that the public actually benefit from. And I rather like the way they put it, and that the public participation applies to all aspects of governance, and the onus is of the concerned public participation must be real and not illusory. I rather like that. Unfortunately, in my view, the Supreme Court in this latest decision have tended to kick that in the teeth and have narrowed it even much more. Perhaps that will be looked at differently. I think from that we sort of read from different sides of the page. Participation, because from the colonial mentality and the colonial government and the way that things were done. During the colonial times, when I was growing up, I mean, everything was a secret. No wonder the government was called Serikali. Sirikali. And because of that, people got to a point where they believed that that's the way government works. And even after we got independence, it continued and got worse. In this case, I think they put out the concept very well, in my view, and it is something that I would love to quote. This latest decision will interface with that, but I think, Prof, for what you, that would be one thing that really stands out for me. Thank you.
Thank you very much. As we go to the public, Judge Lenawala, Yursia has spared you from assessing yourself, but you are the one person who is very active on social media. But you also chair the Judiciary's committee that is dealing with questions on technology. If you...
With Odote, whenever there is criticism, there is defamation, there are insults, there's a particular line around the Supreme Court.
But three there. Look, yes, I know you, Jerry. Jerry, I know very well. We last met at an airport. You see, number 4. So let's go. 1, 2, 3, 4, 5. So let's go. 1, 2, 3, 4, 5. Then after that we can open it up for watu wa kawaida. Number 1 was
Thank you very much, our panelists, Honorable Judge, our former chief, our panelists, Honorable Judge, our former chief. Best I had Attorney General saying it's because it breathes life into Article 60. And my view is it is not a state officer who guarantees title. It's the law. Thank you.
Thank you very much. Lenaola is saved from Dima. Julie. Julie is from ICJ, the last time I checked.
Struggling with the fact that the Supreme Court from its inception was to grapple with the serious human rights issues and the considerations therein. Box us in what is the ideal public participation, but we're not listening to what Kenyans want as the ideal public participation. Thank you.
Thank you very much. Number 3, it was Njeri.
Speak as an insider. We are three of us here. I serve as a magistrate at Jomo Kenyatta International Airport. Don't mind my looks. I dispense justice with all seriousness. I have justice with all seriousness. I have 3 things to say. The first is, Professor Githu, I thank you so much for what you shared about Murwa Tattoo. I didn't know what you said. Thank you very much. My second, or you could be in a court that is in the spotlight for various reasons. Sometimes we don't have a voice. Parliamentarians, the executive, they have ways that they can hit back. For those, you know, if you're able to take on and speak for yourself, then it's possible to do that. But for the greater part of us, we just wake up in the morning and continue doing our work. And the third one, I think, for me, is to His Lordship Justice Lenaola. And let me say to the panel, we talk about
legal education in this country. You are regulators of very high standing. And when we are teaching these rights, we introduce pedagogies that sometimes are hampered by the state
children. And you talked about grandmothers and grandchildren. I have neither. I'm neither a mother nor a grandmother, so it's fine. But I've always been told after 13, between 13 and 19, children are the worst. They go through puberty and they're very difficult. And sort of do things that they're not supposed to. People didn't like, for want of a better word. And you know, we've been told about how they cyberbully. Prof will understand. No, I don't believe he's ever used that, but it was used that just to propagate a cause. I think the judges also are accused, and the executive and the legislature get accused by all sorts of people. Does that mean they stop getting thin-skinned? I think the judges need to get a little, it's not easy, but it's the position you've. The one case, the 2 cases that I have a problem with is the case of Wiba, if Justice Lenaola, you remember. The Wiba case, the work injury benefit case that came to the Supreme Court. That was a very interesting case. It went up to the Supreme Court. I think at paragraph 79, the Supreme Court did say that all matters should go, all matters that have been filed in the Magistrates Court are out. They should go to the director. Even prior to, you know, from the date of the ruling. Is that filed before this judgment came in and hadn't been determined. And you look at it, you start wondering, can the judge said, you know, it's okay. There were people who were going to challenge the Chief Justice's direction before they are done, because you start wondering, you know, and we have enough conspiracy theorists in Kenya to say, oh, there must be a conspiracy. There must be a factory somebody had that had all these cases, and there were, you know, we've got enough of that. And finally, sometimes I believe that the Supreme, and maybe our Attorney Generals should be a little more proactive, because some of these things can come, I believe it's really only the Attorney General, unless I can come, being more alive to what the people, say. Yes, we've got a transformative constitution. I've been told that for 12 years, or from 2010. Some of these people were not born. It's a very transformative constitution. But I just feel that sometimes, yes, the Supreme Court is tied up, but sometimes the mood of the people has to be read. It's got to evolve.
Yeah, you can actually clap louder than that. I will ask the panelists to respond to that first set, then we can come to the rest of us. And we start with Judge Lenaola and end with...
about the bill can guide the courts for interpretation only, as opposed to judges saying what they have to say in society. What is the role of the senior bar? Why is it say the court is contradicting itself? But in fact, I have argued in webinars with the lawyers, show me. Only one young man brought a 5-page document saying Kibos versus Chaurembo, those contradictions. But they're cherry picking. One line, one paragraph from one judgment, then you compare with another and say, there's a contradiction. I have said questions, but sadly, one line on Twitter, 2 lines on Facebook are not sufficient critiques of judgment. And one of the people we work very closely with, as one of the resource persons for the court in our seminars and webinars, is let me not say much about that, but I know there's a crisis. Case, the Torino case, there is a whole spot for us to have a conversation and say to the court, when have you ever reflected and overturned yourself? Because the Constitution says the Supreme Court is not bound by its decisions. But there's reason for us to overturn ourselves. Lastly, I think for the senior bar, and the chairman of the senior bar is here, what happened to respect for seniors by juniors? What happened to the fact that when one advocate is standing, the other must sit down? What is this about pointing fingers at judges and saying, you guys? Where did the rain start beating us? Shouldn't we have a seminar between the bar and the bench where we ask ourselves, why are we?
And etiquette and all that, that's gone down the tube. Anger and confusion that we had. Also, the judge has touched on the whole question of how we all behave. It's unbelievable. I just recently I was watching on television, and it wasn't ever, I think it was YouTube. And it was regard to a matter in which Young Githu has just been involved in recently. Has to go beyond what, I mean, in fact, one sometimes has to look up and say, acting for the fact that they have managed to hold back what they could easily have done. So I think maybe that sounds like old school, but I think it is very, very important. The reverberation in the room makes it even worse. Or a Supreme Court.
There's a question actually from Magistrate.
The Supreme Court has a fantastic future. We forget that they're only 12 years old. And I think Judge Leonardo has just mentioned that. Remember that the U.S. Supreme Court was establishments that we're dealing with. And in fact, to be honest, this Supreme Court has dealt with the questions that the Supreme Court of the United States has never been able to deal with. The Supreme Court have done us proud. They're not faultless. None of us is to do better. So I think that Supreme Court has a great future, particularly taking into account the jurisdiction which the mandate has been given to them. The remit is such that they have a tremendous opportunity to widen the scope. Looking at Article 22, 23, and seeing what is expected of them under Article 163, and they can do massively more than they're doing. But I wouldn't expect them to have done it after 12 years. I think when those of us who are sitting on this side of the table criticizing them get onto those benches and begin to make the kind of contribution that the court realize that there is always headroom and we can move further.
Thank you, Senior Counsel. Let's hear Professor Mugai.
By an old advocate of being very young, Big Freddy has reverted to a very fond way of talking about me, he says young Gidhu. So I've had a good week. Having said that, Carol, you ask what are we go to Parliament. If it's the President or his deputy, they are impeached. If it's a cabinet secretary, we institution ask. Who should we ask? So about what? I have missed. I probably something about it cannot bring cases. Would run their campaigns on the basis that we are going to rein in.
Yes, I think most all the issues have been addressed.
Number 1, and then the lady is number 7, the last. Let's go. And one.
Good evening.
Good evening.
12 protocols observed.